you very much. So I'm interested in exploring the question of how courts do and should use existing licenses to value patents when determining patent damages at trial. And of course, damages have always been important, and become even more so important now after eBay. Injunctions are harder to obtain, and so courts are more frequently put in the position of trying to calculate damages, and especially to calculate damages of the reasonable royalty form for non-practicing entities. Of course, damages calculation is very difficult, and what legal guidance exists is not particularly helpful. Nobody likes the Georgia-Pacific factors. The Georgia-Pacific factors don't tell us very much. So courts are a little bit at sea. So courts have always looked for a market mechanism of some sort that would allow them to try to figure out exactly what a patent is worth. And the method they've used is to look at pre-existing licenses. If the patentee has previously licensed the patent to other entities, those prior licenses might serve as a good market guide for what that patent is actually worth. There are a couple of sort of rules that courts use. The most important of these, at least for the purposes of my talk, is that they prefer licenses that were negotiated, sort of my terminology, in the wild, meaning outside of litigation. Two firms are talking to each other, they agree to license the patent. There's no case that's been filed at that point, no litigation discussion going on. The reason being that the courts seem to think that the litigation and the cost of that litigation will distort the price that the licensee is paying the licensor for that patent. So generally speaking, they will allow litigation settlements in as evidence sometimes, but only very recently, only really since the Rescue versus Lancet case in this decade. And still they're disfavored. They're considered less accurate than licenses negotiated sort of at arm's length between two business entities. Okay, so first I want to show what's wrong with that, or sort of at least explain the understood problems about this. So first and foremost, all licenses are negotiated in the shadow of litigation. There's simply no getting around that, no matter what the court wants to think about it. Without the threat of litigation, why would you ever pay for a patent license? What are you getting from that patent license other than the right to be free from suit? And in point of fact, courts generally say that they're not interested in looking at licenses where other things are transferred other than the patent license. So of course, in the real world, you might transfer some latent knowledge along with your license, you might transfer a trademark, but the whole point of the court's exercise in valuing a patent is to try to separate all of that out away from the license and look to the pure value of the patent license itself, and that pure value is determined solely by litigation. Just as an aside, this is a respect in which patent law is really pretty different from most other areas of law. It's very hard to find other pieces of property or other sort of goods in the world, other legal rights, that have basically no value other than their in-court enforcement value. And to see those things be traded in this sort of way doesn't happen very many other places, so we have something going on in patent law where we don't have a lot of other good models for it. Okay, so imagine a patent under P, and we've got potential license, defendant licensee L1. P and L1 agree that the patent is worth $10 million if P were to prevail in court, if the patent is held valid and infringed. Worth should be in quotation marks. Sort of the point of the paper is going to be that that idea of worth is a little bit fuzzy. And let's say they think it's 25% likely to be valid and infringed. So worth just means they think a court would award $10 million in damages. So P licenses for about $2.5 million, 25% of the $10 million. That's about the expected trial outcome, or thereabouts. Okay, now let's suppose P goes and sues another alleged infringer, L2. Court has to determine the value of P's patent. Court wants to know what's the price of the license that P and L2 would have agreed upon ex ante before the litigation ever started. Let's imagine that P wins this second lawsuit. So the court observes the license between P and L1, the first licensee, and observes that that license was worth $2.5 million and says, aha, that's the correct measure of damages here. We're going to award $2.5 million to P in their lawsuit after prevailing against L2. But of course, the problem is that that $2.5 million figure depended on the fact that P and L1 thought that the patent was only 25% likely to be valid and infringed. And here we have a trial that has already concluded where the patent has been found valid and infringed, and the court, by its own doctrine, is required to reconstruct a hypothetical negotiation in which the parties assume that the patent was valid and infringed, which P and L1 most certainly were not doing. They were assuming the patent was 25% likely to be held invalid, or some such thing. So the court needs to know that 25% number. They can only reconstruct the actual figure that P and L1 placed on the patent if they can know that percentage. But they can't know that percentage. It's private information that P and L1 are the only ones who hold. And in a second I'll get to how they might try to discover it. Okay. Relatedly to all of this, there's a circularity problem. Licenses are based on damages at trial. That's the whole point of trying to take the license out. So if damages at trial are based on licenses as well, now the tiger is sort of chasing its tail. It's not clear which of these things is the chicken, which is the egg. All this makes a lot of sense for us. So imagine, and this circularity, it creates, anytime you have a circularity like this, you create spirals, either upwards or in this case, downwards in value. So let's imagine that P contacts L3, another putative infringer of the patent, and they agree that the patent is 50% likely to be held valid and infringed. Maybe validity is not so much an issue because P's already had the patent upheld in the litigation against L2. Now it's mostly just infringement. P and L3 are going to observe the case of P versus L2 and see that the court awarded $2.5 million in damages. And they say, aha, if L3 loses a trial, P will get $2.5 million in damages. But there's only a 50% chance that L3 will lose a trial, so now they're going to license for $1.25 million. But the value of the patent is going down over time just as a result of this circularity that connects patent licenses and values at trial. Okay, so I don't think, and all of this, by the way, as I say, all of this is driven by the fact that the court does not understand what that license between P and L1 was really all about. Okay, so I don't think any of this should be particularly controversial or exciting to anyone. What I really want to talk about are potential solutions to this problem. What do you do in light of these sorts of issues? So there are really three possible options that I want to run through. The first is to determine a multiplier. So think back to the PL1 example. If P and L1 think that the patent is 25% likely to be held valid and infringed, and they agree on a $2.5 million license, when the court looks at that license, maybe it should apply a multiplier to pump up the value of the patent again in accordance with the fact that the patent has now been determined valid and infringed. So you could determine a specific multiplier for a given case. You could use a standard multiplier. Let's just apply a blanket multiplier across all cases and not worry about the particular case. And when I show you the problems with one, you'll see why two might be attractive. Or number three, we can take care in trying to select the right sorts of licenses to use. So I'll talk about that idea. All right, so let's talk about determining a multiplier first of all. So a court can try to apply a multiplier to a license. If the patent was 25% likely to be valid and infringed, then you apply the multiplier of 4, you get back to the right $10 million number. This is what some courts occasionally try to do, although there are other courts who don't even allow this sort of multiplier information into evidence. There are, unfortunately, lots of problems. I think that says 4 serious problems. I'm only talking about 3. I decided that 2 of my problems are the same thing. So 3 serious problems. First of all, what's really at issue here is the set of subjective beliefs that P and L1 had about that patent at the time they licensed it. We don't care what the reality was. Maybe P and L1 were completely wrong, and that patent is 90% likely to be valid and infringed. That's not what matters. What matters is that the license that P and L1 negotiated at arm's length was based on some subjective belief, or maybe non-mutual subjective beliefs. If they don't agree on what the percentage chance is, then that license is even less valuable. But even making a stronger assumption that they agree, based on a set of subjective beliefs about whether that patent is likely to be valid and infringed. And it's going to be extraordinarily hard to discover those subjective beliefs because the court doesn't have access to any of that information. It's private to those parties. It's going to be difficult to uncover. How are they going to know what the two parties were thinking, and in particular, what sort of information they had in front of them? At this point in the trial, you've had a full trial on the merits of this patent between P and L2. And they'll have discovered all kinds of information. So when an expert gets up there and testifies about whether somebody back in the day would have thought the patent was likely to be valid and infringed, they're going to do it based on all this other information they have now at the end of the trial. Whereas earlier on, maybe P and L1 didn't have that information, maybe L1 is missing a crucial piece of prior art, maybe they don't understand something fundamental about the way this patent works or how to interpret the claims, or any number of other things. So that information is going to be very, very difficult to discover because it's private and because it's subjective. Secondly, there are going to be these sort of weird inconsistencies between the liability and damages phases. So the patent holder, having just conducted a trial in which they argue that of course the patent is valid and infringed, you'd have to be an idiot not to realize the patent is valid and infringed, would now be put in the position of turning around and saying, oh yeah, but at the time I negotiated the license with L1, the first licensee, we thought the patent had no chance of being held valid and infringed, so you need to apply a really big multiplier. They're going to stop arguing that the patent is so good and start arguing that the patent is really bad all of a sudden. And the defendant, L2, is going to do exactly the opposite thing. So they might be in a position where they will try to be making arguments that are contradicted, that they're stopped from making. It's going to distort the entire litigation process. And thirdly, the court is going to be at real pains here, the court or the jury is going to be at real pains here to try to separate what they've just decided at the liability phase from what they're now being asked to think about at the damages phase. So in the liability phase, the court has just found the patent valid and infringed. And now they have to sort of abstract away from that and think about the probabilistic chance that they might not have found that patent valid and infringed originally. And that may be extraordinarily difficult for a court to do. The court will be bound and determined to follow what its own beliefs were in the first place. You could try to get around this by separating. Maybe we have a liability jury and a damages jury, or a liability judge and a damages judge. All of these things complicate the trial process a lot. All right, we could use a fixed multiplier. So let's forget about everyone's subjective beliefs. Let's just say, hey, look, patents usually win at about a 25% rate in trial, so maybe we'll apply a multiplier of 4. That's going to undercompensate some patents and overcompensate others, but maybe that's not so bad, actually. So the undercompensated patents are going to be the weak patents that had low ex-ante chances of winning a trial. The overcompensated patents are going to be the strong patents that had a very high ex-ante chance of winning a trial. Anoop Milani and I have a paper where we say maybe we ought to be doing this generally to account for court errors, to reward people who have good patents, punish people who have bad patents. It's fine sort of in one shot. It becomes very serious if you iterate it though. So imagine you've got a strong patent that's 75% likely to be valid and infringed, $10 million in damage if valid and infringed. Okay, so they licensed the patent for $7.5 million. That's the license. If you're using a multiplier of 4, when that patent holder goes to the next licensee, they realize they're looking at $30 million of damages based on the first license at trial. So now they're going to take a license for 75% of 30 million, or 22.5, and the value of this patent is going to spiral infinitely upwards as the patent holder goes and talks to more and more possible licensees sequentially, because that multiplier so overcompensates the patent holder for the actual strength of the patent. You're going to see the exact outcome. I won't run through the example. You can guess. You can see exactly the opposite phenomenon with a weaker patent, a downward spiral in value. This spiral is just the inevitable result of a circularity in which licenses depend on damage to the trial, and damages to trial depend on licenses. If you're not hitting the number on the nose, you're going to spiral upwards or downwards. So that's why I don't think a fixed multiplier is such a good idea either. Okay, lastly, the court could try to pick the right licenses to use. Only use licenses that are really informative. So licenses are going to be discounted to reflect the probability that plaintiff is going to win a trial. Plaintiff's only 25% likely to win a trial. Defendant's only going to pay 25% of the value. So what you really want is a best case where the parties agree that the patent is 100% likely to be valid and infringed. And so the licensee is going to pay full freight for the patent. Where are you going to find a patent that's 100% likely to be valid and infringed? Well, you might want a settlement that's negotiated during litigation, or even better yet, a litigation that the defendant was really badly losing. That is the kind of litigation that courts are most averse to. They're least likely to want to use a patent license that was negotiated at the end to a trial that had proceeded for quite a ways, especially where one party seemed to be losing much worse than the other. But I guess what I want to suggest is I think that that's exactly the type of license we ought to be using, because it's going to be much closer to this kind of true value that the court seems to be looking for. So what this means, I think, is that the court's preference for licenses negotiated outside of litigation, licenses that were not settlements of existing litigation, is precisely backwards. All right, where does this leave us? I think my conclusion, unfortunately, is that there are no easy solutions. I think it's sort of in the nature of legal scholarship to want to write comedies rather than tragedies, where every problem has a solution. I don't really feel like there are a lot of solutions. I think this is kind of a tragedy. I think that courts are going to have to treat licenses as floors of values of patent, not as point estimates, not as accurate gauges of what those patents are worth. And unfortunately, that just means rely more heavily on the traditional methods. Have the expert, comb through the patent and look at the industry and do all of that stuff under Georgia-Pacific that we think is so difficult and troublesome as is. Unfortunately, I just don't think that there is a particularly good alternative option in this case. So with that, I will stop and I welcome your questions and comments. Yeah.
So what about a suggestion that maybe the assumption that remedies should be based on the license where there's a hypothetical ex-ante negotiation where you assume validity? What if we actually change that aspect of the law? What if we step in and say, no, a weak patent, if this is probabilistic, right, you're at 10% chance, that's actually prevailing, that actually realistically reflects, after the fact, you won in this case, right, but what you're really entitled to here is a reward for a patent where you had a 10% chance of victory. So we just changed the nature of the law, and then all of a sudden, changed the black letter law, and then all of a sudden the licenses that are out there beforehand become really good indicators. And furthermore, it does precisely what you suggested you wanted to do in this other paper, which is that the licenses for the stronger patents actually will be end up with larger damage awards in court.
Yeah, it's a great idea. It's really tempting. For a second, I thought that was the right way to go also, but actually, that creates another gigantic problem, which is that it discourages settlement and licensing to a tremendous degree because it sets up a heads I win, tails it's a tie situation for the licensee. So let's say I've got a patent where I think that the court will award $1 million in damages if I think that the value is $1 million in damages, but there's only a 50% chance that I'm going to be that the patent's going to be held valid and infringed. You might settle for $500,000. Maybe we think that's the value, but if you settle for $500,000, the next person says, well, it's $500,000. If I can either settle for $500,000 or I can go to trial and have a 50% chance of paying nothing and a 50% chance of paying $500,000. You have to, so if there's no penalty for going to trial, because the price you pay after it damages the trial is exactly the same as the price you pay for a license ex ante, but trial you have a percentage chance of winning, then there's no reason not to go to trial other than the cost of litigation. Right. So it dramatically, that's gonna create downward spirals, also dramatically diminish anyone's incentives to settle in the first place. But it's a nice idea. Ted.
So there's another big problem in a lot of licensing cases in that you don't even have a license of the patent being asserted in many cases, particularly NPE cases where everyone refuses the license. So now you're dealing with licenses of similar patents.
Yeah.
You could even further down the rabbit hole of licensing determinations. Mm-hmm. In terms of distortions in litigation, the problem is that many licenses and settlements are around the same amount as the cost of litigation. So when they're of the same magnitude, it's very difficult to use those values to inform the court or the jury of anything about the value of the underlying patent. And then the third point is related to a suggestion I made in a recent paper. Why are we doing this at all? Because the point of patents is not to remedy a wrong, but to promote innovation. We have all sorts of great information at the damages phase that we don't have when we grant a patent about cost of R&D, risks, all these things that we are using to try to gauge essentially through a variety of proxies at the patent stage, at the grant stage, that we don't need to use anymore. Why don't we just look at all these underlying factors and set rewards that we think will induce optimal levels of innovation?
Okay, so on the first 2 points, I completely agree. I guess all I want to say is, even under the best of circumstances, even in those cases in which courts are most confident that they're looking at a patent that provides valuable information, even then, I do not think they're looking at a patent that provides, or a license that provides valuable information. So even in the sort of core case where you might say, all right, putting aside all of the problems that Sickelman has brought up that are absolutely correct, here we've got a license that we can use. I don't even think then we've got a license that we can use. So I'm trying to say even the last few holdouts, I don't think are so valuable. As for setting damages to provide the proper incentives for innovation, I think that that's absolutely right as a theoretical matter. I'm taking the law basically as given, and the court says the way to do this is you want to just figure out what that ex ante negotiation would look like, and I'm just asking the question, how are we going to go about doing that? But I agree, I think that there's a lot of sense behind the idea of completely reformulating how we go about measuring damages in the first place, along lines that you or others have suggested. If we did that, we might want to use licenses very differently. I'm just saying under existing law, given what courts are trying to do in current status quo, what are their options, and how can they use those licenses in a way that would be helpful? Peter?
So you advocate using licenses from settlements, or where the litigation is going down with the defendant, but what about kind of irreversible investments in holdup? So you might be willing to pay much more in a settlement because you've actually built your factory around a particular patent, and wouldn't that artificially inflate the price?
Yeah, totally true. There are, these are lots of caveats that go in the paper and don't make it into the 12-minute talk. You're absolutely right. That's part of the fear, is that holdup will distort the license prices. I think that holdup can be a very big problem in some cases. Holdup is not such a big problem in other cases because sometimes the factory is not limited to the particular product. It's very easy to change the product line in a way that makes it non-infringing, etc. So for certain, courts will have to be careful about holdup and dealing with these problems. I guess one thing you could say about all this is, in most of these cases, the circularity will cause the value of the patent to sort of spiral downwards. Problems like holdup will usually make the patent license look, make the patent look more valuable than it actually should be. So I don't know, maybe this is a good corrective to other tendencies to overinflate the value of patents. That's possible. I guess I feel like we shouldn't be kind of blindly making two mistakes and hoping that they cancel each other out, even though at some level maybe they would. John.
I think this is a good paper project. I do think, you're just highlighting one of the problems. What is also a major problem, of course, with licenses is generally they're massive bundles with the patent portfolios that are being licensed, and trying to extract what should be the value of a single patent from that, or even a few patents from that, can be extremely difficult. And from my experience as a court-appointed expert on damages, mercifully, spared actually having to write a report by Judge Posner who managed to dispose of the case. Otherwise, it was a huge problem, and the validity problem, at least in that context, was seen like a second-order issue from just trying to get some kind of estimate of how we should value this technology generally.
Yeah.
So, just besides what I'm sure you already know.
Totally agreed. I mean, my response is the same. I think this is very similar to Ted's point, right? There are lots of these very intractable problems. Sometimes courts say, aha, here's a perfect situation, and all I want to say is, nope, not even there. Not even there is a perfect situation. Even in the core case where you think you have an easy answer. Peter.
There's sort of a rationality problem in the litigation itself. How much they've thought through the damages, given that they have, to win the trial over liability. But you're sort of putting the defendant, you're putting the parties in an awkward position, or I guess it would probably be the patentee, because they would in some ways want to reveal some weaknesses of their case in trying to show the multiplier.
Yep.
And so then you're about to have post-trial motions. And I guess maybe that's where you're going with the fixed multiplier. But there's just the reality that trial lawyers, litigators are never going to want to have to put their cards on the table when there's still appeals and a lot of other things that are, in play.
Yeah, that is his point. Right? I completely agree. Right? That is his point. The point is that you're asking these parties to make arguments that are completely inconsistent with the sort of arguments they want to normally make, and they're not going to want to do it, or they're going to distort things in some way. So the court's not going to get really full and fair and complete briefing that will allow it to make actual decisions. The patentee will do it. The other side will do it too. They'll want to sort of, they have incentive to say, well, actually, the patent really was pretty strong in ways that might give up their appeals case or something. So that's exactly my point, is that you're not going to get information.
I was dozing, but thank you.
My pleasure. Thank you all very much.